Trial of warrant cases on police report. A warrant case is a case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. When such a case is instituted on a police report, the magistrate is required to follow a specific procedure prescribed under the Bharatiya Nagarik Suraksha Sanhita 2023. The procedure is designed to ensure a fair trial while protecting the rights of both the prosecution and the accused. Legal provision. The procedure for the trial of warrant cases instituted on a police report is contained in Section 269 to 274 and Section 279 of BNSS 2023, which is corresponding to Sections 238 to 243 and Section 248 of the CRPC 1973. Procedure for trial of warrant cases on police report. Supply of police report and documents. Before the commencement of the trial, the magistrate must satisfy himself that the accused has been supplied with copies of the police report, statements, confessions, and other relevant documents as required under Section 230 of the BNSS 2023. This ensures that the accused is fully informed of the case against him and can prepare his defense. Discharge of the accused under Section 270 of BNSS 2023, after considering the police report and accompanying documents and after hearing the prosecution, if the magistrate finds the charge to be groundless, he shall discharge the accused and record the reasons for doing so. An order of discharge can be passed only when no sufficient ground exists for proceeding against the accused. Framing of charge. According to Section 271 of BNSS 2023, if the magistrate is of the opinion that there is ground for presuming that the accused has committed an offense triable as a warrant case, he shall frame a written charge against the accused. The charge must then be read and explained to the accused, who shall be asked whether he pleads guilty or claims to be tried. Conviction on plea of guilty. Under Section 272 of BNSS 2023, if the accused pleads guilty, the magistrate may, in his discretion, record the plea and convict him. The plea of guilt must be voluntary, clear, and unambiguous. It should be recorded as nearly as possible in the words used by the accused. Prosecution evidence. If the accused refuses to plead guilty, claims to be tried, or the magistrate does not convict him on his plea of guilt, the court proceeds to record prosecution evidence under Section 273 of the BNSS 2023. The magistrate may issue summons to prosecution witnesses and record their evidence. The accused is given an opportunity to cross examine the witnesses. Defense evidence. After the prosecution evidence is completed, the accused is called upon to enter his defense under Section 274 of the BNSS 2023. The accused may produce witnesses, documents, or other evidence in support of his defense if the accused applies for the issuance of process to secure the attendance of witnesses or production of documents. The magistrate shall ordinarily issue such process unless the application appears vexatious, intended to delay proceedings, or likely to defeat the ends of justice. Judgment. After hearing both sides and considering the evidence on record, the magistrate pronounces judgment in accordance with Section 279 of the BNSS 2023. The accused is either acquitted or convicted based on the merits of the case. Case law Binod Bihari Bahera versus Niranjan Sahu 1979 47 CLT 447. The court held that an order of discharge, once passed, is final and cannot ordinarily be altered or reviewed except as provided by law or for correction of clerical or arithmetical errors. C.H. Venkateswara Rao versus State of Andhra Pradesh, 1979, CRI LJ 255. The court held that after a charge has been framed and the accused enters upon his defense, he has a valuable right to summon witnesses in support of his case. The court may require reasonable expenses to be deposited for summoning such witnesses. Importance or significance. The procedure for the trial of warrant cases instituted on a police report ensures fairness, transparency, and adherence to the principles of natural justice. It provides adequate opportunities to both the prosecution and the accused to present their respective cases and helps the court arrive at a just decision based on evidence. Conclusion. The trial of a warrant case instituted on a police report follows a structured procedure under the BNSS 2023, beginning with the supply of documents and ending with the pronouncement of judgment. The procedure balances the interests of justice with the right of the accused and forms an essential part of criminal trial jurisprudence.